President, please be seated. The court is now back in session, as the chamber already notified the parties to the proceedings this morning. Now we are entering the second session because we already concluded the first session on the medical report. During the second session, as emphasized, we focused mainly on the observations by the parties to the proceedings concerning the result of the medical report on Mr. Nuon Chea. And this report may impact on the severance of the proceedings in case file 002, and the chamber will issue our decision on this in due course. And if the chamber were to rule that Mr. Nuon Chea would be fit to stand trial, then we would also envisage what consequences would we face accordingly. And if Mr. Nuon Chea were to be ruled to be unfit to stand trial, then what would be the impact of such ruling? And as indicated, the chamber would be issuing this decision very soon, and we would like to also hear from parties to the proceedings, starting from counsels for Mr. Nuon Chea first. You may proceed.
Thank you, Mr. President, Your Honours. I think that at this point in time we do not really have any submissions to make. The impact of the health situation on the continuance of the proceedings, if you were to judge that he is fit to stand trial, has of course a high, we have to cross the bridge when we get there, quality to it. As you are aware, and as the medical experts have explained, his health situation could deteriorate at any given moment and suddenly. So if you were to judge that he is indeed fit to stand trial, we'll just have to see how it goes, if he is indeed able to follow the proceedings in the holding cell, whether he's actually capable of understanding what is happening during these proceedings, and if that at any given day in the near future might change, then obviously we as his counsels will inform the court promptly and adequately. So at this point in time, we just hope that your decision on the scope of the trial will soon be rendered, and that from that point on we'll continue, if you were to consider our client fit, and that, like I said, we'll cross the bridges when we get there.
The President, thank you. Counsel for Mr. Kilsumpon, you may have a few words on this if you would wish to do so. Counsel Kong Samon, on behalf of Mr. Kilsumpon, we do not have any position concerning the severance. We neither support nor disagree with the severance, but practically we can see that Mr. Khieu Samphan's interest would be damaged if the severance tends to delay the proceedings or prolong the proceedings. We have already made a request to make sure that Mr. Khieu Samphan is provisionally released because we would like to make sure his right is properly exercised. And we still stand by our position that we would like Mr. Khieu Samphan to be provisionally released, and again we would not wish the proceedings to be severed. The President. Thank you. Now we would like to hand over to the prosecution.
Thank you, Mr. President. I also have extremely limited comments to make. In essence, how does this affect the position of the co-prosecutors that was presented to you on the 18th of February? Well, we've heard today the medical experts have concluded that we have a frail 86-year-old man with a number of stable and controlled conditions who is mentally and physically fit to stand trial. But, of course, you will remain concerned about his condition, and naturally so. And we still maintain that because of that concern, you should adopt the second option that was given to you by the Supreme Court chamber of one smaller trial on some portion of the indictment and give due consideration to reasonable representativeness, which you recall I explained in great depth at the hearing in February. And we still say that S21 would satisfy that representativeness standard, and I'll refer you back to paragraph 50 of the Supreme Court chamber judgment. I'd also ask you, when you return to your chambers, to read paragraph 43 of that judgment, which deals with exactly what we are addressing here today. And I'll read the last sentence of that paragraph because I think it's worth considering. And I quote as follows: "If anything, the trial chamber's doubts about the co-accused's abilities to participate in a lengthy trial militates in favour of exploring, at the earliest instance, possible ways of shaping the scope of case 002/01 that could maximise representation of the totality of the charges against the co-accused and thereby optimise the meaningfulness of the justice to be rendered in the shortest amount of time." And so, not to keep repeating myself, but we maintain the position that including S21 in this case, in one single trial, will satisfy that requirement. Thank you very much indeed for being able to make these comments.
The President, Judge Cartwright, you may now proceed.
Thank you very much, President. Yes, you did explore in great detail your concept of reasonable representativeness in the hearing which began on the 18th of February. And you emphasised also then that S21 would provide additional crimes that would add to the general representativeness of a severed trial. You underlined on that occasion that there would be additional underlying crimes against humanity, 2 or 3 of them. But you also mentioned that grave breaches, that is, war crimes, would also come into play if the Chamber decided to bring back the full scope of S21 into a severed trial. You mentioned that I think 3 witnesses and something like 200 additional documents might be required. I'm just wondering how we could cover the issue of international armed conflict with 3 witnesses, all of whom worked at or were detained at S21, and some documents. And you may recall that this was a significant issue in the first trial, and it took significantly more than that sort of cross-section of evidence and documentation. So I'm very interested to know just how much additional time you think simply war crimes, that is the issue of international armed conflict, might take. Because, as we all know, it's a precondition to considering evidence in relation to war crimes. Thank you.
Yes, thank you, Judge Cartwright, for that question. We did actually address this issue last time, in February. It was addressed, but we can address it again. I can allow Mr. Lysak, who in fact addressed it last time, to speak about the evidence that we rely on for that particular jurisdictional issue.
Thank you, Judge Cartwright. Trying to recall the details of my response before, I would point out a couple of things. One, the most compelling evidence that proves both the existence of the armed conflict and the accused's knowledge of it are documents that are already in evidence in case 002/01. And specifically, I would have in mind by that documents such as reports and telegrams that were regularly sent to the leaders in Phnom Penh reporting on the armed conflict, standing committee minutes and minutes of meetings where conflicts with Vietnam were discussed, and also announcements issued by the party leaders themselves referring to the Vietnamese conflict. There are a number of those. So on the documents itself that are already before the Chamber, the evidence is quite overwhelming in terms of both the existence of the armed conflict and the accused's knowledge of it. A number of witnesses have made reference to that, and I believe I also noted in my comments last month that there are a number of military witnesses upcoming who were directly involved as well in the military conflict as it escalated in 1977. So from our perspective as the party with the burden of proof, we are quite satisfied that the documentary evidence, coupled with some of the testimony that will occur, will prove beyond a doubt the existence of the armed conflict.
Yes, thank you. I read those submissions as well. However, in the first trial before this Chamber, which is not directly associated with this trial, there was significant oral evidence on this very point because the documents to which you refer were not so specific as to the time of the armed conflict, which will of course be relevant. Therefore, I would like to know if you think that it can be done just with documents and without witnesses, and as I recall, we had Nayan Chanda for a significant period in the first trial commenting on these very issues of armed conflict. Therefore, I am, as you can see, sceptical about your claims that this can be done just on documents. And time issues are of fundamental importance in this trial, as we have been reminded over and over again, and indeed, as the trial chamber itself has said right from the outset.
Yes, thank you, Judge Cartwright. I would submit to you that when we put those documents before you, if you wish to hear a presentation from us, they will be overwhelming, both in terms of establishing the timing and the knowledge of the accused. And I am not saying that we are only relying on documents. There has already been witness testimony regarding incidents of military conflict with Vietnam. And if you add S-21, it will be an issue that will certainly be touched upon with other people. In terms of Nine Chanda, I do not believe it is necessary to call an expert on the armed conflict. I believe the contemporaneous evidence and the testimony of the recipient witnesses is enough. That is our position.
The President, thank you. Finally, I hand over to the lead co-lawyers for the civil parties. Counsel Pich-Ang. Good afternoon, Mr. President, Your Honors, and parties to the proceeding, and civil parties who are present in today's hearing. As for the impacts or the consequence as a result of the report by the experts on the current case, we actually had the opportunity to ask the two experts, Professor John Campbell and Dr. Sina Fazol, very comprehensively, and we have listened to the questions by the prosecutor as well. Of course, the two experts have done their job meticulously, and according to their report, there is no reason why Mr. Nguyen Chea cannot attend the proceeding. So the any request to separate Mr. Nguyen Chea or Mr. Khieu Samphan in separate trials, we are of the opinion that this is not a real possibility here, and it is not warranted, because Mr. Nguyen Chea has the necessary capacity to attend in this courtroom. Of course, we know that Mr. Nguyen Chea is 87 years of age, so it is understandable that he is prone to various ailments at this advanced age, and we can also foresee that in the future, from time to time, there might be health issue arising. However, the civil parties do not see the importance to separate the case into mini trials. And in addition, the civil parties would like to urge the trial chamber to proceed expeditiously, and we do not want the proceeding to cover only a small portion of the facts. Actually, we want the trial to be as comprehensive as possible, because we want to see the justice done completely. This is the opinion of the lawyers for the civil parties, and as my esteemed colleague Mr. Hong Kum Soon said, we support the various mechanisms in order to support Mr. Nuon Chea, particularly to ensure that his health status improves so that he can participate fully in the proceeding, particularly to provide him the opportunity to tell the truth to the people. And that is all for me, Mr. President, and I would like to cede the floor to my esteemed colleague if she wishes to make any further statement.
Yes, I would like to make a few remarks to spell out our position as civil parties. My first remark is that once more we find a situation in which the Chamber and the parties are confronted with this problem of finding some balance in terms of representativeness, and we want the case to proceed expeditiously. This is a very thorny problem, and that is why we are revisiting this matter again today, after having discussed it some weeks ago and a few months ago. Regarding the severance per se, I believe we have stated on several occasions in this courtroom that we were not against the idea of severance, insofar as it remains factual, and I insist on this word factual. And to the extent that the Chamber seeks to establish sufficient representativeness in this trial, since it is increasingly likely that we will not have any trial after this one. So we stated that we are in support of a factual severance, provided it is sufficiently representative. And I have pointed out that it is not justified, nor is it lawful, to base the severance on legal characterization of the facts. And I think that the severance is not possible, so we request that the Chamber should not decide that there will be a severance. A severance in terms of the personal jurisdiction is not good. And in light of the findings of the experts, there is no basis for a severance of this case. And we would wish, therefore, that Khieu Samphan and Nuon Chea should be joined in a single trial as much as possible. Let me add a few words on the issue of death, which was mentioned and which is weighing so much on our remarks and on adversarial discussions and perhaps the decisions that will be made. It is unfortunate that the death of persons, particularly the accused, as something that would spell the end of the trial. Death is an element that has hung over this trial since the very beginning for at least 10 years. However, this doesn't mean that the death of the accused is tantamount to the death of the civil parties and witnesses and persons as important as Mr. Van Nath, who is a major witness. Death is inherent in this trial. However, I think that we should not overly focus on time limits, 3 months, 6 months, 3 months. That doesn't make sense. I think the expert witnesses were very clear on that. They didn't give any prognosis on that. His answer was based on common sense, and each and every one of us could have done the same. It would be unfortunate for us to hear of the death of Mr. Nuon Chea in 6 months. However, this should not dictate time limits. It's not only death that is important in this trial. There are other things that we need to establish and prove. I would also like to state that if death were to come about, which is possible, or if other problems cropped up and put an end to this trial, which is also possible, I think it is important for us to underscore the fact that proceedings is all what is said here, including what the civil parties have stated here in terms of evidence, history, the background, and their understanding of what happened. All of this is important and will remain important. So such adversarial proceedings will remain essential throughout the trial. As I read everywhere that this trial will be a failure, I would like to lay emphasis on this. Because we can say that we don't have any control over death. Of course, it is a failure, and it is a half-truth, and it is also a challenge or an affront to the civil parties and all those who have sought to establish the truth and to reconstitute the memory and what happened. Death is something we have no control over, but I believe that there are other things happening here than the death of the accused. We should not forget that, and I plead once more that we should proceed in a trial that has meaning, with proceedings that have meaning, with representativeness that is significant. And unfortunately, there may be issues that will put an end to the proceedings for reasons beyond our control.
The President, thank you, and I now hand over to Judge Jean-Marc Lavange. You may proceed, Judge.
Oui, merci.
Thank you, Mr. President. I have a number of questions to put to the parties with a view to clarifying the positions of all concerned. Let me start with the defense for Nguyen Chia. A while ago, we heard Counsel Son Arun talk about the opinion of the medical experts, and if I understood him correctly, he was saying that Nguyen Chia was not fit to stand trial and to participate in these proceedings. I also heard Counsel Kope explaining that it may well be that the issue of fitness to stand trial is not the current problem we face at this point in time, but that it could happen in future, and that when we get to that bridge, we will cross the bridge and make certain requests at that point. Should I understand that there is some disharmony in the position of the Nguyen Chia defense team? What is the position of the two counsel for Nguyen Chia? What kind of requests or applications are you talking of when you said when we get to that bridge we'll cross it and we'll ask certain questions? Could you shed light on your position, please?
The President, yes, Judge, you may proceed.
Je ne sais pas si c'est à moi de prendre la parole.
I do not know whether I have the floor or the defense for Nguyen Chia to respond to my request for clarifications. My request was quite clear, or would you like me to repeat it?
No, Judge Levine, your question was quite clear. I understand your question, but rest assured we are never disharmonious. That's all I have to say.
Donc nous avons une défense à deux.
Are you saying that you are singing from two hymn sheets?
Apparently, my colleague is saying there's no translation. Is that correct? Or?
The question is whether you are singing from two hymn sheets.
Also, I understand your question, but we're not. No. I see that. You can ask more questions, but you're not going to get an answer from our side on this specific issue.
D'accord.
Very well. That is not exactly what we refer to as stereophony. Now, I have another question for counsel for Mr. Kyo Sampan. We heard his counsel say that an application for release of Mr. Kyo Sampan may have been filed. If that has been done, I haven't seen that application. That said, I would like to know at this stage in the proceedings whether that application has any link with the request for severance, with Mr. Nunchia's her status now and the decision by the opinion of the experts that he can stand trial, he's fit to stand trial. To avoid a situation of vagueness, can you please clarify your position? Is your application for release of your client, Mr. Kyo Sampan, linked to what we have just discussed today? Is it linked to any application for severance? I haven't quite understood your position on severance. Are you applying for severance or not?
Counsel Kung Samon. Thank you, Your Honor. As for this question, I would like to clarify our position as follows. First, our application for a release on bail is under preparation. We have not yet submitted to the Chamber. It is still being discussed among ourselves. Secondly, in relation to the severance of case 002, to date, we have not received any decision of the trial chamber in relation to this issue. That's why our application for release of our client does not have any clear basis yet. Any reason that may provide prejudice to the right of Mr. Kyo Sampon will depend largely on the decision of the severance of the current case. And I would like to inform the Chamber of our position once again that the issue of severance of case 002, by virtue of the principle, it should be severed only when there is a conflict in this current case. And secondly, it may be necessitated by the interest of justice. Then the Chamber may examine based on these two factors. However, there has not been any conflict of interest in the current case. So the first factor may not be the case that the Chamber may take into consideration when considering severing the current case. Secondly, if the trial chamber is to sever this current case, then the risk is that it may lead to the prolongation of the case, and the severance of this case may also include other issues that may be subjected to arguments by other parties as well, and this will definitely prolong the proceedings.
Bien.
Very well. I believe we'll just have to content ourselves with that response. I have a question now for the co-lead lawyers for the civil parties. We heard from the national co-lead lawyer. I understand that his wish is for all of the facts alleged against the accused be included. Now, perhaps I misunderstood something, or perhaps this is a matter of interpretation, but I did not fully understand as to whether or not he was in favor of a severance or a single trial on all of the charges. Therefore, that is my first question. And when I heard Counsel Simoneau-Faure state that ultimately the civil parties would be in favor of severance, I did not understand the basis on which they would be in favor of a severed case. Do they subscribe to the position of the co-prosecutors, or do they stand by a different position, and if so, which one?
Counsel Ping-ong. Thank you, Your Honor, for putting the question for clarification for us. I apologize to Your Honors if position I made earlier on was not clear enough. I will speak rather slowly this time. We are not requesting for one case. We are not, our position is not actually asking for one case in 002. And neither are we requesting that there should be only one judgment in case 002.
All of the facts and rendered with one judgment.
We actually envisage that the first segment of trial should be concluded in a fairly appropriate time, and we actually subscribe to the position of the prosecutor in this respect. In addition, we are earnestly requesting to the Chamber that following the first segment of trial, we suggest that there be another segment of trial, because the civil parties as well as the victims would like to see the trial with other facts, for example, on the charges of forced marriage, forced labor, and other victims. They want to see the trial of those facts as well. So we actually want to have the initial trial that is going to be defined by the upcoming decision of the trial, and we would also like to request that there will be subsequent trial as well on other facts during the period. I hope I have made myself clear, Mr. President. Thank you very much. The President, thank you.
Okay.
Yes, you may proceed.
I believe that my learned friend was very clear. We do stand by the same position. We are certainly in favor of severance in terms of the kind of severance per se. We believe that the trial chamber cannot proceed with a severance on the legal characterizations of the crimes. we believe that the characterization can only be defined at the end of the trial. And in terms of the factual allegations, we have never diverted from our previous positions, which was to stand by the co-prosecutors. Thank you very much. Judge Leverne. Thank you very much for those much appreciated clarifications, and I have further questions for the parties. It would appear that most are in favor of severance. The Supreme Court has asked the trial chamber to discuss with the parties future intentions or projects for future trials. That is to hold further and subsequent trials. Since we are addressing this matter, there is a plethora of possibilities before us. Either we envisage a second trial once the first trial has been adjudicated upon, that is, once a judgment has been issued, and perhaps even once the judgment has become definitive. Or we can hold concurrent proceedings, that is, following an initial severance while the trial chamber is drafting a verdict for the first trial. We can also envisage holding other trials and other proceedings under the guise of a second trial. Neither of the scenarios are identical to one another. I recall that the co-prosecutors, not too long ago, had indicated that the holding of concurrent proceedings was not ideal, as it was less preferable to have a first trial and then a verdict that would be definitive and that could serve as a basis for establishing judged and adjudicated facts. We also must take into consideration the decision rendered by the Supreme Court chamber itself under paragraph 51. According to which, proceeding with several trials judged by a single bench of judges could lead to a certain number of difficulties. Including a bias on the part of the judges. Now, this has perhaps given rise to some thoughts or positions. Perhaps the parties would like to make their contributions to this debate, at which point I would invite the parties to do so. I understand that the defense for Nuon Chea is not in favor of severance, and perhaps it would wish to expand on its position, and now would be the most appropriate time.
Thank you, Judge Lavergne. As we have argued during the hearing in respect of the question of whether there should be one big trial or rather several trials consecutively, we have taken the firm position that one big trial should have the preference. There are quite some reasons that we have argued this. One of the most important reasons is that the Supreme Court chamber seems to have indicated that it might be problematic from a viewpoint of bias of the trial chamber if we are to have the end of one trial and the continuance of the second trial. We have also stated that one big trial has our preference in relation to the accusations against our client. We feel that the whole, complete content of the closing order should be the scope of this one big trial. We have also argued that simply and solely adding S21 does not meet the reasonable representativeness test. As a matter of fact, in answering the earlier submissions of the international co-prosecutors, if you see and if you read carefully the media reports which have come out after the death of the co-accused Ing Sari, one can read the word genocide in almost every article, I presume in every article on his death. We have argued earlier that not prosecuting Nguyen Chia for genocide would not meet that reasonable representativeness test. And in addition to this, although nobody in this courtroom knows how long our client will still live, it might very well be that he is indeed completely recovered from the acute bronchitis and that he might live another 3 to 4 years. Maybe even 6, maybe he will be 100. So, actually, the reports and the results of the examination of the experts today seem to indicate extra grounds to our earlier viewpoint that there should be one big trial based on the scope, on the complete scope of the closing order. And we submit, we repeat our earlier viewpoint, our earlier stand in this.
Thank you very much, Counsel Koppe. And a question to other parties. Now, in the scenario that we do hold several trials, the trial chamber would like to know that above and beyond the first trial, what are the facts that have to be judged immediately after the first trial? Counsel Koppe has talked about the charges of genocide. Is this a view that is shared by other parties? That such a charge should be tried immediately in a second trial. Can we please hear from the defense for Mr. Kyu Sompong, unless the defense for Mr. Nguyen Chia wishes to add something?
Counsel Kong Som-on. Thank you, Your Honor, for the question. I would like to point out that Your Honor already pointed to the assessment by the Supreme Court chamber that there would be a prejudgment if the hearing was not yet concluded and we proceeded to another case at the same time. If the Supreme Court chamber has recommended so. This gives rise to appeal by parties to the proceedings based on this ground. So if the trial chamber is now conducting hearings on parts of case file 002 and continues to hear other parts of the proceedings in case file 002 at the same time, this leads to the prejudice or prejudgment of the cases, and it is our position that severance should never be in place, because the Supreme Court chamber rules that this is the only way to avoid such prejudgment. And if there is a new panel that is available to adjudicate or to conduct the proceedings when part of the case being adjudicated by the current chamber, then that would be also a remedy. But with that, I can conclude that we are of the opinion that severance order is not appreciated.
Thank you, Judge Laverne. You know, we set our position out very clearly in the last hearing on this matter, and the difficulty that we see of moving to the next trial pending judgment and appeal in the first trial are the issues that I referred to last time. There are legal obstacles that are in place that actually prevent us from going down this road. And the Supreme Court chamber pointed that out. This is the issue of using facts from the first trial in this second sub-trial. And the answer to those questions have still not been answered. I see that as a real problem. And I don't know, I can't give you answers on how to overcome that. As far as the second panel being established and hearing a case afresh, I mean, I think we've got to be absolutely frank, all of us at this stage. The financial situation of this court, we know it very well. And to establish a second chamber, recruit judges from overseas, international judges, and commence that trial, I think it's highly unlikely that that is an option that will work. It was suggested by the Supreme Court chamber, but I think the other factors that the International Civil Party lead co-lawyer was referring to, we have to confront that. It is a reality. We still maintain our position that in all likelihood this will be the only trial that takes place. This will be the only trial. It will be the last trial of this court, and that by adding S21 it will make it a reasonably representative trial. In respect of genocide, you asked about genocide. Of course, genocide is the most serious charge against the accused. But let's not recall, and not to diminish that allegation, that crime, that most of the killings that took place here, the vast majority of the killings were of Khmer, of Cambodian, and that's never been characterized as genocide. And indeed, if you address the killings that took place in S21, you will be addressing a proportion of the greatest part of the killing that took place. Remember that genocide only concerns the Vietnamese and the Cham, and there are legal reasons for that we know about. So, again, I would just reiterate our position. It's set out very well in our submissions from February the 18th. We maintain that position. Thank you.
Perhaps in response to the first question asked by Judge Laverne with respect to the proposals put forward by the Supreme Court chamber, with all due respect to the Supreme Court chamber, I would submit that its proposals are entirely unrealistic for the exact same reasons that have just been advanced to you by the co-prosecutor. I believe that it is totally impossible to start a second trial during deliberation of the first, because the first trial warrants a verdict on appeal before any possibility of holding a second trial. With respect to establishing a second panel that would work concurrently with yours, again, as the co-prosecutor stated, I think this is a totally unfeasible option given the state of affairs. It is totally impossible. With respect to your second question, we have not been able to consult with our civil party lawyers with respect to a second trial. However, I do understand that the trial chamber is following a factual and chronological sequence, and I believe that this would be the logic that imposes. However, I cannot comment further on that. I can simply say that the issue of the legal characterization of crimes must be considered and is a separate matter in and of itself. Thank you. I believe that my co-lead lawyer has a few comments to make.
Counsel Pick On. Regarding question number 1, and that there should be another hearing being conducted when the judges of the bench are considering the writing the judgment for the pending, the current case. To us, by doing so, it is not easy for the handling of the whole case completely, because we are afraid no judgment would be rendered expeditiously enough if the approach is applied. We, the lead co-lawyers for the civil parties, would like the judges of the bench to hear the evidence in the case and then adjourn so that judges can render a judgment, so that the judgment itself can be rendered as soon as possible. That's what the civil parties have been longing for, and we already note that Mr. Ieng Sri had passed away when no judgment or conviction has ever been rendered. And with regard to question number 2, civil parties focus more on the facts that are very much relevant to the civil parties to be addressed as priority. Nonetheless, we would like to have some time to consult with the civil parties to see or to bring the most representative cases before the chamber, and we would like to include also the forced marriages and life at cooperatives and detention centers across the country during the regime, so that the sufferings or damages civil party had suffered are properly covered. The President. Thank you. The hearing on the report by the medical experts concerning the health and fitness of Mr. Nuon Chea to stand trial, and also the observations made by parties to the proceedings concerning this have now come to the conclusion, and also the hearing on the impact of the severance order has come to an end as well. As the President of the trial chamber and on behalf of my fellow judges of the trial chamber, we would like to thank you parties to the proceedings for today's sessions. Your observations and comments are very important for our decision, and the chamber is to render the decision in due course. As I emphasized, the chamber will rely heavily on the observations or conclusions by parties to the proceedings and the medical reports and the testimonies of the medical or the experts during today's sessions. And once again, I would like to thank you, co-prosecutors, the lead co-lawyers for the civil parties, the defense counsels, and the security personnel, TC staff members, and also the interpreters and other relevant units for helping these hearings. The chamber also wishes to inform that there are still two issues. First, the chamber plans to announce its brief decision concerning the fitness to stand trial of Mr. Nuon Chea on Friday, the 9th of March 2013. The chamber will notify the parties in the near future, and at the same time, the chamber also has a small ceremony to be administered before the chamber, because we have a new investigator who shall take the oath before the chamber to make sure the investigator can fully take the office. The President, I have already made it clear that the chamber will rule on the severance of the case and also the fitness to stand trial of Mr. Nuon Chea at 9 a.m. on Friday, and the chamber will notify the parties before the hearing commences on the 29th of March 2013, and I hope it is clear now. The President, we would like to proceed to the oath-swearing ceremony. The new investigator will take the oath according to internal rule 16. The new investigator who has been accredited has to take the oath before a chamber. So now the trial chamber would like to administer this oath swearing. The composition of the judges during this ceremony includes I myself, the President, Judge Suvakatrai, Judge Yasakhan, Judge Uottara, and Judge Jean-Marc Levin, along with two reserve judges, Judge Fence and Judge Tumani. Mr. Perry is the investigator present or available to take the oath. The greffier, Mrs. Plenty Julie, who is the new investigator for the Office of Co-Investigating Judges, is present and awaits call by the chamber. Court officer is now instructed to bring in the investigator into the courtroom. The President, Mr. Co-Prosecutors, would you like to make any observation concerning this proceeding before us now?
Thank you, Mr. President. We don't have anything to say. Thank you.
The President, thank you. Next, I would like to proceed to read Prakas number 40 by the Ministry of Justice. Prakas on the accreditation to be offered to the international investigator for the Office of Co-Investigating Judges at the ECCC. According to the Constitution of Cambodia and other regulations, hereby decides to offer the accreditation to the new co-investigator with the following identification, name and surname. Plain Julie, born on the 12th of July 1973 in Canada. Date of starting service, the 9th of March 2013. The investigator mission or service will be expired after the mandate of the ECCC also expires, or if or when the service of the investigator expires. And the individual, as indicated above, will have to exercise or carry out this broadcast effectively from today onwards. Signed, His Excellency Ong Wong Watana, the Minister of Ministry of Justice. The chamber would like to invite Madam Investigator to please rise. Court officer is now instructed to bring the oath to the investigator so that she can read after us.
I solemnly declare that I will perform my duties and exercise my powers as an investigator of the extraordinary chambers in the Court of Cambodia for prosecution of crimes committed during the period of the democratic Kampuchea, honorably, faithfully, impartially, and conscientiously, and I will not seek or accept orders in regard to the performance of those duties or the exercise of those powers from any source other than the co-investigating judges of the extraordinary chambers in the Court of Cambodia.
The President, thank you very much. You are now instructed to sign on this oath with the greffier. You may be seated now, please. The President, the oath-bearing ceremony now comes to an end, but the Chamber wishes to also have a few words to you that now you have already been selected to work recruited by the recruitment panel, and secondly, you have been accredited fully as an investigator for the office of co-investigating judges, and thirdly, you have already taken the oath before us and everyone, and the Chamber hopes you will do your best to fulfill your duties as you already stated in the oath you read out. And finally, the Chamber would like to wish you the very best. The hearing now comes to an end. The Chamber will adjourn, and security personnel are now instructed to bring Mr. Nuon Chea back to the detention facility. The court is adjourned.